is Mike going over one of the two buyer's agency agreements with the Greater Cincinnati, the Alliance of Greater Cincinnati. So this one is specific exclusive buyer agency agreement, and that is for an address only. And so here in line 2, it talks about you put in the address, the city, the state, the zip, and the county. In line 3, or section 1, more what we're talking about here is who are the parties involved. So line 4 would be the buyer's name, line 5 would be RE/MAX Alliance, line 6 would be the RE/MAX Alliance agent, and then line 9 would be the beginning and the beginning and end date. So they're referring to it as the commencement date or the expiration date in line 9 as to when this contract specific to one address is in effect. So I will point out here on line 10, in the event during the term an offer to purchase or exchange is being actively prepared or negotiated, and or there is a fully executed contract to purchase for real estate, the term shall extend beyond the expiration period stated above until the closing of the purchase. So if you're under contract and this were to expire, it would carry forward and still be in effect. Section 2, duties of the licensed salesperson. It's the same duties we've always had with fiduciary responsibilities. You're required to comply with Ohio law and as it relates to the code of ethics, federal and state fair housing laws. Duties to the buyer. During the term of the agreement, the buyer shall work with the buyer brokerage during the term and cooperate in good faith with its agents. Buyer confirms that the buyer has or has not entered into an agreement that any other real estate brokerage firm for this real estate or other real estate could conflict with the agreement. So I think if you're going to dot loop this document, this is one of those text box fields that you definitely want to make sure that the buyer is the one checking the box. I could even see that this could be a section that you might want the buyer to initial. Maybe you want to bring it out as a point of emphasis that they are in fact confirming that they have no other agreement in place. Because in line 21 it says the buyer understands that signing more than one representation agreement could result in the buyer being responsible to pay additional compensation or other fees. Under section 4, talks about agency. The licensed salesperson is appointed by an agent of the buyer under this agreement with respect to real estate. The agency relationship is exclusive with respect to real estate, meaning during the term of this agreement, the buyer will not appoint another real estate agent outside of the buyer brokerage firm to act as the buyer's agent. Buyer confirms that prior to entering into the agreement, the buyer has received the consumer guide from the buyer brokerage and that the buyer has signed a separate acknowledgement in receipt of the same. Fair housing, that hasn't changed, so that still is the same, so we don't need to really go into that. Section 6, anything that's bold and capital is important. Section 6 is legal notice regarding compensation. Broker fees, commissions are not set by law and are fully negotiable and may be paid by the seller, the buyer, the landlord, the tenant, or a third party, or by sharing or splitting these fees and commissions between brokers. Section 7, fairly self-explanatory. Again, this video is public facing. I can't get into numbers going into these documents, not knowing who the audience is. But section 7A is where you would put a dollar amount and or a percent as it relates to your fee. Section B is a retainer that you would put in there, and if you do have a dollar amount retainer that is paid up front, and that dollar amount would apply towards the broker commission that was set in 7A. If you had something unique like a tech fee, administrative support, you would use 7C. And as it says in line 54, leaving 7A, B, and C blank would be construed as zeros or not applicable for the method of compensation. So that's important that you want to mark something in 7A, B, and C. Down in line 56, at the direction of the buyer brokerage may seek such compensation from the listing brokerage or seller in order to offset some or all of the compensation otherwise due from the buyer under the agreement. Otherwise, specific above compensation is due and payable upon closing. So that still is what we've talked about. We're working to negotiate the best situation for the buyer, and if we can negotiate that from the seller, then that's obviously good for our client. Line 61, if within blank days, if left blank, it'll be defaulted to 60. I see some people put lengthier time periods like 90 or 120 days. But if this buyer executes a contract to purchase real estate, the buyer agrees to pay the broker commission as provided in this agreement. If you have any other terms or conditions, they're allowing for Section 8 to put that in there. Section 9, self-explanatory, deals with Ohio. Section 10 in line 65 is an indemnification paragraph. You can read that on your own. Section 11, buyer acknowledges that the buyer has read this agreement and understands to its terms and to the agreement, and that the information contained herein is true and accurate. Then it's going to be signed by, there's places for 2 buyers, and then the bottom section is filled out by the agent of the brokerage. So I hope that is helpful, and be looking for the buyer's agency agreement that is not address specific, which will be done soon.